Good morning, everybody. Welcome to today's session, and it is on flexible working applications and home working adjustments. Now, if you've been here before, you'll know the rules. If not, these are the rules. Your microphone is muted automatically, so don't worry if you need to cough or sneeze, you're not going to interrupt or interject anything that we're talking about today. We also have a handout attached, two versions of the same handout, one in black and white and one in colour. The black and white is there just if you're like me, you like to print things off and take notes. There's that one, but it also includes helpful links and tips. And particularly today, what we've done is we've included some extra information at the back end of the presentation for you. So please download that now and don't forget. Not only that, you can send us your questions by pressing the speech bubble with a question mark embedded in there. That's for us. So if you ask a question and we can't get around to answering it, we'll answer it after the session. We'll be in touch with you directly via email, but we do have time for a Q&A near the end. Also, we'll be sending you a copy of today's recorded session around about an hour after it's concluded. So if you do get pulled away from your desk or you just want to watch the content again, don't worry, you can do. So for now, what I would recommend is just sit back and enjoy and think of any questions that you possibly want to ask our speakers. Now, on the subject of today's speakers, I'm joined by Via Plus HR technical consultant Kelly Armitage and senior HR advisor Katie Reese, and they're going to share their expertise on how to manage flexible working requests and when these may be required as part of a reasonable adjustment for an employee. Would you like to introduce yourself, guys?
Hi, yes, my name's Kelly. I've worked in HR for nearly 20 years, working mainly for large corporate organisations, including the chemical industry, security, criminal justice and transport sectors. So I've completed my level 3 and 7 CIPD qualification, and I've worked for Advisor Plus for 12 years. My role as a HR technical consultant means I get to work closely with the client and the advisory team, as well as having the opportunity to work on a variety of HR consultancy projects. I have experience working on complex HR topics such as grievance, disciplinary, managing underperformance, flexible working, and many others. Katie, do you want to introduce yourself?
Yes, hi, I'm Katie. I've worked in HR and employment law for 25 years now, and then I've been an advisor here with Advisor Plus for 3 years. So before this, I've been self-employed. I've worked in private practice, in-house for companies and for consultancies, and that's as a litigation fee earner, providing advice, consultancy, and advocacy. So I've represented employer and employee clients in mediations, arbitrations, and in the employment and employment appeal tribunals.
Fantastic. A wealth of experience between you both there. Super duper. Now, today, this is what we're going to be looking at, and this is what our expert advisors are going to be focusing on. So just to quickly run down the list for you, we're going to be understanding flexible working, trends in hybrid and remote working, benefits and challenges for employers and employees, legal framework and policy requirements, manager responsibilities and decision making, the risks of incorrect handling, and then finally we're going to wrap up with some case studies and practical examples as well as a mini Q&A. Now we'll make sure that at the end of the webinar you can access the slides that we've used throughout the session, and we're going to share the webinar recording as I mentioned before, so you can watch back on demand and share any links to the portal of the policies and areas you need to pay particular attention to. We're going to share more on how to access these at the end of the session, but for now, we're 3 minutes in, I think we should get going. So Kelly, could you please start by giving a quick overview of what flexible working means?
Yeah, absolutely. So flexible working means changing the way that an employee works. So this might mean a change of working hours, such as reducing their hours, change of the start or finish time, or compressing of hours where someone may wish to do their full contractual weekly hours, but work them over 4 days per week instead of 5. It can also be a change to where they work, such as full-time home working or some hybrid working where they request to work at another company location or home for some of the working time and their contractual location for the remainder. Other requests include term time working or annualized hours, where an employee works an agreed number of hours over the year, but there's flexibility as to when these hours are worked.
Now, have you noticed a rise of hybrid and remote working applications after the pandemic?
Yeah, so prior to COVID-19 pandemic in 2019, early 2020, working flexibly was largely uncommon for most organisations, with only around 5% of the workforce in the country working from home. So during lockdown, businesses needed to find ways in which their employees could work more flexibly. And in most cases, this meant a lot of employees beginning to work from home. So after lockdown, many employees wanted to retain that flexibility, and some organisations did find it beneficial in some ways, such as being able to downgrade the size of their offices or keep their employees permanently working from home as a cost saving. Whereas other organisations found that flexible working didn't work for them for various reasons, and they're now looking to return the employees back to the office. There can be some differences in employees' expectations, though, when it comes to flexible working versus what's operationally feasible for some flexible working requests, or misunderstanding from historical informal agreements. I think the biggest expectation has come from employees who were deployed to work from home during the pandemic. I think the expectation is that they would continue to work in this way once lockdown was lifted. But for many of the organisations, this just simply wasn't their preferred business model. So the rise in hybrid working and remote working applications may also stem from flexible working becoming a day one right in April 2024. So just to be clear, employees do have the right to request flexible working, but they don't automatically have the right to have flexible working. Many employees interpret the day one right to mean that they should be allowed to work flexibly as long as they follow the flexible working procedure, and this isn't the case. So some organisations don't have the technology required for employees to complete all aspects of their role at home. And depending on the size of the company, it may be too costly to invest in technology to ensure that employees are capable of doing everything that they need to in order to ensure that the quality or the performance on the business is not at a detriment. Now, depending on the nature of the role, there may not be enough work for the employee to complete outside of their normal working environment. And where flexible working can't be accommodated, excuse me, there are 8 specific business reasons that must be used to reject a flexible working request. And more information on this can be found on the Sage Knowledge Portal. So the legislation around flexible working is expected to tighten in 2027, where a flexible working request is being refused. As it stands at the moment, employers must confirm which of the 8 business reasons the rejection falls under, and whilst many organisations already do this as standard practice, it will become law that all companies must also give a written explanation as to why the refusal is reasonable. Should there be any employment tribunals because of a flexible working request being refused, i.e. a failure to make reasonable adjustments, for example, a tribunal would review the explanation and consider if the refusal was reasonable based on the information that was provided to the employee.
Superb. And we've got those 8 business reasons as a slide as part of the handout as well, if you'd like to review. We've put that in addition. But thank you for that, Kelly. Now, what do you think are some of the benefits and challenges of flexible working for the business and for the employee themselves?
So looking at some of the benefits, those who are able to work flexibly can feel a higher level of job satisfaction, and it can give people a greater level of work-life balance, including those who have care and responsibilities. So during the pandemic, data showed employees adapted quickly to the new ways of working. And since the pandemic, more employees now see the personal value in continuing to work in this way. With ever evolving technology, home working doesn't appear to have reduced productivity. And in fact, some people's productivity may have increased without the distraction of a noisy office environment, for example. Historically, new parents may not have been able to return to work following family leave, such as maternity, surrogacy, or adoption leave, as they struggle to balance childcare with working. So if businesses can be flexible with when and how employees work, it can mean retaining valuable employees and retaining that experience and tacit knowledge without the expense of having to recruit and train new employees. Allowing flexible ways of working can bring benefits for employees who have a disability, who may find it challenging in attending an office environment full time. So it's especially important to consider when looking to support employees with reasonable adjustments as part of a medical condition. It can also attract employees to a business where potential candidates are looking to work more flexibly. So this can bring in a broader range of talents to the organisation by inviting more candidates with different experience, knowledge and qualifications. And by not considering flexible working arrangements where it is possible to do so, some potential candidates who really value the opportunity to work flexibly may be discouraged from applying for roles. So whilst there are benefits to flexible working, there are some challenges to be mindful of. So the ability to work from home or work flexibly does depend on the type of role worked. For example, whilst physical work can't be completed remotely, this can cause frustration within the business where some job roles allow home working and others don't. In these cases where home working isn't an option, there may be still some consideration for those to potentially work flexibly in some other way. And so if this can be considered, this should hopefully avoid any friction within the team. So we discussed earlier that increased productivity can be a key benefit for those working flexibly. However, this can also be a detriment where employees see this as an opportunity to redirect their focus from their work, for example, taking more breaks than they would otherwise, or in some cases, look after relatives whilst working. So this in turn may mean that those employees who don't work flexibly may end up picking up more of the workload, which again may affect working relationships. It can also be a potential health and safety concern, especially if they're looking after small children whilst working. So where there is an agreement that someone can work flexibly, it's important to set out clear expectations at the start that work should remain the priority and not letting themselves be distracted by other factors. There can also be some mistrust from managers or colleagues that the employee is not putting in as much effort as those in the working environment. And again, this can lead to friction between some members of the team. Some employees may become less flexible about attending meetings if they get used to working from home for a certain number of days in the week. It's therefore advised to agree some flexibility where possible when considering homework. So, for example, agreeing if days can be changed, should that be required. The employee would keep the same number of home working days, but they would swap which day they work from home if they were required to attend an office meeting or a team event, for example. And finally, some people also prefer to work flexibly from home, but for others, this can lead to decreased mental well-being, with some feeling isolated or lonely. It's therefore especially important that contact is maintained from a well-being and a duty of care perspective.
Spot on. Thanks, Kelly. Now, Katie, could you talk us through how a flexible working policy should set out the process? And could you tell us a little bit more about the legal obligations for business, when it comes to flexible working requests?
Yes, absolutely. Thank you. So the statutory right for the employee to make a flexible working application is contained in the Employment Rights Act. The right was originally introduced only for employees with particular characteristics, and at that stage they also had to justify their application. And over the years, this has evolved to be a wider right for all employees. And then on the 6th of April 2024, that right was expanded to allow all employees to submit 2 applications per year rather than just the one previously. Also, the need for the employee to explain the impact their application might have on the business, that was removed. And also the period in which a flexible working decision must be given by the employer was shortened down from 3 months to 2 months. So those people who are self-employed, they are workers, and agency workers are generally excluded from the ability to make flexible working requests. Now, ideally, businesses should have a flexible working policy in place, and that should explain to employees how to make an application and also explain the process that follows. And this should include things like the application must be in writing, the application should be clear about what the requested arrangements will be, so whether they would be permanent or fixed term and when they should start. Also, if someone's returning from maternity leave and would like the new arrangement to start on their return back, they should make the application in plenty of time in advance to do that. If an application is described as temporary, it must still contain an end date. So employees aren't entitled to an arrangement that's open-ended for them to decide when it ends. They're just not. And then a consultation meeting, generally labelled a flexible working meeting, should be arranged to discuss any request, and a decision should then be communicated back to the employee within 2 months of that application. So I just want to touch on some points to note out of the process. So if an employee comes to their manager to discuss a possible application informally, for example, to see if their manager can foresee any issues, that's absolutely fine. Caution should just be exercised, though, about the manager going that bit too far in indicating any really firm outcome to avoid any arguments about procedural unfairness. Now, any application should be lawful and it should be reasonable. So, for example, an employee shouldn't be asking to work a really long shift without a rest break, as of course that would be contrary to the working time regulations and unlawful. And likewise, as we've touched on, they shouldn't be asking to work from home at the same time that they plan to be looking after children or being a carer for relatives, for example. Now, if an employee is asking to vary their working hours, for example, to compress their hours, they need to be really clear about when they propose their new start and finish times to be, and their breaks as well, how long they're going to be, so that the manager can decide if all in all it's a reasonable request. If there are concerns about the request on the part of the manager, they should be discussed in that meeting, along with any alternatives that can be agreed and any kind of compromise. Now, if the employer agrees to the request or any compromise, this needs to be confirmed in writing. And specifically, that writing needs to include that it is an amendment to the employment contract. Has to have that in it. Now, if the request is rejected, the reasons put in writing should really reflect those that have been discussed in the meeting. The letter should contain enough detail that the employee can see exactly why it was rejected and which of those 8 or more business reasons applied to them. And as touched on, that right of appeal should also be confirmed in writing. Now, if there are concerns or doubts about whether a proposed arrangement will work, it is possible to agree, yes, an application can be done permanently, but subject to a trial. And if that trial doesn't work out, for example, if the employee's productivity drops right off, then the rejection likewise needs to be done in a letter, and again with that right of appeal offered. So if there's going to be any delay to the process, we've talked about it being 2 months, then the employee should be asked to confirm in writing their agreement to that delay. Now, delay could be all sorts of things. It could be because of a trial, the employee's availability for meetings, or any other factor. They just need to agree that. And then whilst the manager chairing the meeting may need to get some kind of input from colleagues about any practical issues that might arise, it's important that they should really be the one making that decision. Just like the manager chairing a disciplinary or a grievance meeting, they should be the actual decision maker. Now, I just wanted to touch on what is that legal obligation exactly. So is it simply to consider the request, or is it to accept it? Now, interestingly, the obligation of an employer under the Act is to accept an application unless rejection can be justified. Now, that's quite significant to bear in mind from a positioning point of view. So ultimately, the wording is all geared around requiring employers to genuinely consider any application on an individual basis, rather than just rejecting it on generalized grounds. And essentially, if a sound, individualized rationale for rejection can be shown, then generally speaking, a rejection will be legally compliant. It's important to bear in mind that when looking at the level of detail needed, that the 8 business reasons, they're categories only, and so it's necessary to also show how they relate to the individual's own role. So managers would need to avoid factors that don't relate to the individual. So for example, a business frowning upon home working, or worries about whether one person will feel that it will open the floodgates to everybody else and have everybody expecting the same arrangement. I mean, the floodgates are already open in the sense that an employee can apply, any employee can apply. They need to understand, though, that their application will be dealt with on its merits also at the time that they make the application. So as touched on by Kelly, and hopefully as somewhat of a reassurance to employers, employees do not have that right to have exactly the same contract terms as everybody else, even though some employees may still believe that there is. So for example, if a business is open 24 hours a day and gradually all staff apply to work days only in response to hearing that one application was actually granted, it is still going to be fair to start rejecting those applications at the point that there wouldn't be enough staff to cover those nights. So it's fair to describe the approach as first come, first served.
That makes absolute sense, Katie. And are employers obliged to accept all flexible working requests if it's considered as a reasonable adjustment for an employee who has a disability?
Yes, so employers who have that legal obligation to make reasonable adjustments for employees who have a disability, definitely, but that doesn't necessarily mean that they have to be arranged under the flexible working process. So that said, if an employee really wants to use the flexible working process to seek those adjustments, they can do, and it does need to be considered in the way that we've discussed. But if they make an application and then agree, yes, it's not needed, then they just need to confirm that withdrawal in writing, just to avoid any ambiguity. So where an employee is absolutely sure that they want to use the flexible working process, even for disability-related reasons, there can be some nuance with that, as the considerations required for flexible working considerations, and then on the other hand, the obligation to make reasonable adjustments, they're slightly different. So let's take, for example, the scenario of an employee who's in a role that requires her to attend in-person meetings, but due to immunosuppressing treatment that she's receiving for cancer, she can't travel. So she makes a flexible working application to allow her to work remotely, and her attending online is possible, so it might be reasonable to allow it as a disability-related adjustment, perhaps for the duration of the treatment and until her immunity improves. You might decide, however, that her remote attendance does impact the quality of the meetings, and therefore you have a valid business reason to reject the flexible working part of the application. So you would position this that whilst the flexible working application to permanently vary the contract is rejected, you are still agreeing to the arrangement as an Equality Act reasonable adjustment to be in place for as long as that's medically needed. But what the business shouldn't do in that scenario is just refuse to consider the flexible working request at all. So we would advise also any employer to get advice on a case-by-case basis where there might be that overlap in process if you've got any doubt in your mind.
Absolutely. If in doubt, give a shout, I suppose, just get that understanding and the consideration. Now, on consideration, what consideration should managers make when they're deciding on if a request can be accepted or not?
That's a good question, and I'll answer that one. So as Katie explained earlier, the employer is obliged to consider a flexible working request and accept it unless there's a genuine business reason not to. So should the request be rejected, managers need to explain which of the 8 business reasons the request was rejected under. So when looking at the request and whether it's feasible to accept it or not, managers should consider factors such as how much of the role can be completed at home, i.e. is the technology there to allow them to work in the same way and complete all the tasks as they would do in the office? Does their role require face-to-face collaboration with their team or the customer? And will remote working have an impact on this? Will there be any detriment to providing expected customer service? Or other factors to consider are things like costs. So would there be a savings for the business, or would the business need to provide additional technology to enable the employee to work from home? So whilst an employee no longer needs to explain why they require flexible working, as they once did prior to April 2024, it's likely the employee will naturally discuss their perceived benefits for them working flexibly during that formal flexible working discussion. And if so, this should be a factor to take into consideration, as there may also be some benefits to the request for the company. For example, if you've got an employee who has a lengthy commute and the request is for some or all home working, this may give them more job satisfaction and could mean the business retains a valuable employee who may have been considering looking for another role closer to home. It's especially important to consider any flexible working for employees who have a disability to avoid any employment tribunal claims for failing to make reasonable adjustments. Even if the request cannot be accepted in full, managers should discuss any alternative options that may be accommodated, or if they're unsure if part of the request can be accommodated, a trial is usually best practice. Should the request not be feasible, managers would have more evidence to demonstrate why the request could not be accepted when documenting this in the outcome letter. And then should the employee then appeal that decision, the appeal manager will be more informed as to exactly why the request could not be accepted, as it will have been trialled rather than based on an assumption. An important point to note is that a manager must consult with an employee if they do intend to reject the flexible working request. So this means a formal discussion between the employee and their manager to discuss the request, understand the impact or the benefits of the request, and discuss any alternatives if it may seem likely that the request can't be accommodated. If, however, the request is accepted in full, there's no requirement to hold a formal meeting.
Thanks, Kelly. And how should a manager confirm the outcome to the employee?
So whether the request is accepted or declined, all minutes of meetings should be kept on the employee's file, and ideally a copy shared with the employee. So the outcome should be provided in writing and sent to the employee. There's no set timescale on holding the formal meeting, but the final decision must be made within 2 months, including any appeal, or if, as Katie mentioned, there was an agreement to extend that 2-month time frame with the employee. If the request is accepted either in part or full, the employee will require a change to terms and conditions letter if the request means any change to their contract. So, for example, change to their hours, their location, or pay, and this must be sent to the employee within 1 month of that change. The employee would then have another opportunity to put in another flexible working request within 12 months. The change would be considered a permanent change to the employee's terms and conditions unless the acceptance was for a temporary period of time. If the request is rejected, the outcome letter should clearly document the reason for rejection and include as much information as possible to help the employee understand why it couldn't be accepted and under which of the 8 business reasons. And ideally, the letter will also include any alternatives that were considered and why they couldn't be accommodated. The employee should also be given the right to appeal that decision, detailing the time frame of the appeal window and who they should put their appeal in writing to.
Spot on. And again, those 8 business reasons are attached in the handout. So if you want to download that now, it's a copy of all the slides, including some extra bits at the end for you. But moving on, Katie, what if a manager feels the request would cause problems for the company, but is struggling to list this under one of those 8 business reasons?
Yeah, thanks. So for managers who realistically know that some arrangements might end up being inconvenient to the business or just less than ideal, there might be a natural temptation to think in more general terms when considering flexible working applications. And it's also human nature to sometimes consider if an employee deserves those accommodations or to think about how others might feel about somebody getting an application to work differently to them accepted. To keep compliant, though, managers should just focus on if it's workable in the individual's case and just try and set aside any frustration. Likewise, with new employees who maybe didn't mention anything in the recruitment process, but then suddenly requested a contractual change through the flexible working process, it can be frustrating, but that is their statutory right to recognise. So bearing it in mind, it can be helpful to ensure that managers make decisions on applications. They're really clear on what their obligation is and how they need to position their concerns in order to remain compliant. And they also need to pause to think through any potential bias issues that might creep in. So whilst applications might on the one hand be pretty straightforward to handle, training can really help to ensure that managers appreciate the necessary individualized approach, regardless of any generalized policies that a business might have, and to ensure that they stay compliant and they don't create any avoidable risk for their business. Now, an example of bias could be the interplay, for example, between the flexible working process and any internal hybrid working policy that a business might have. So many businesses and organizations have spent time drawing up policies that cover the business approach to hybrid working and home working, which have been really helpful in nudging or getting reluctant employees back to spending that required time in the office and demonstrating that they apply a fair and balanced process when doing so. So having a hybrid working policy has also avoided businesses having to deal with a river of flexible working applications from employees who might have been worried that they might be forced back to work full-time in an office when they've got nice and used to some home working. It's important to bear in mind, however, that hybrid working policies are usually non-contractual in their nature, and non-contractual hybrid policies are simply a way of allowing for the management of office attendance expectations for employees who were always contractually office-based, but who'd maybe been permitted to work from home for some or all of the time. For those employees who don't find that a hybrid policy is enough for them, they are entitled to make that flexible working application. And we have to bear in mind that the flexible working application entitlement is for an employee to ask to work differently to any existing arrangement. So to suggest that a flexible working application would have to be rejected or would be rejected on the basis that it's contrary to a hybrid working policy, for example, would be to effectively refuse to consider that request. Or if we look at it a different way, just not to acknowledge the right that the employee has. So whilst hybrid working policies are great for the general employee population, it's just important to bear in mind that they don't stop individuals asking to work differently, making an application, and for that application to have to be individually considered.
Superb. I think I was one of those ones that needed nudging. I turned into somewhat of a house cat after COVID, but I'm back in the office now. Now, with that, are there any risks in not managing a flexible working request correctly?
Oh, that's always good to hear. Yeah, there are definite risks of failing to correctly consider an application, and of course, that can result in risk to the business. So that risk can arise in one of the following ways. So number one, the Employment Rights Act itself protects employees from suffering a detriment or being dismissed because they've made that flexible working request. So the fact of it should never be held against an employee. Number two, the same Employment Rights Act also gives a specific right of claim to employees whose employers have not considered their applications or have not considered them adequately. So please bear in mind that an employee doesn't need to have left the business to be able to make a claim against that business. And that's why it's so important to carefully consider the request, and also that managers can evidence what they considered as part of their overall decision making. Now, number three, for risk, whilst an employee doesn't have to leave the business to make that claim that we've discussed, there's also the possibility that they do, and they make a constructive unfair dismissal claim where they find the rejection unreasonable. Number four is finally the risk of discrimination claims. Now, they would arise under the Equality Act. And of course, decisions should be free from any obvious discriminatory factors such as age, gender, etc. But decision makers should also think about whether there is any angle of unintentional indirect discrimination in their decision to reject. So for example, if we refuse to accept a female employee's application to reduce her hours without really thinking about it, then this could also be indirect discrimination on the grounds of sex, given that women statistically carry out more childcare than men. So although there is a risk in not looking at the applications fully, the fundamental question of whether an application would be workable is ultimately for you as the employer to decide. And as touched on earlier, employment tribunals appreciate that you know your business best, and they absolutely wouldn't be looking to step into your shoes to decide what you should or shouldn't have done. So in summary, as long as a decision is sufficiently explored on an individual basis and it's reasonable and any rejection falls under one or more of those 8 business reasons, then that risk is really minimized. And as we always say, documentation, like in every area, is absolutely key to evidence if that's needed.
Always document, always document. Brilliant, brilliant, brilliant. Now, what I want to finish up with before we get to the Q&A is just to go through some case studies highlighting the different scenarios that managers may come across when dealing with flexible working requests. So over to you, Kelly, for the first case study.
Thank you. So the first case study is an employee who requested full-time home working, and the case study details how a manager considered that request. So Donna's a fairly new employee with 7 months service. In her previous role with another employer, she worked from home most of the week and found this beneficial for her work-life balance, as she likes to log off and be at home with her family rather than sitting in traffic for 40 minutes every evening. As a newer employee, Donna felt uneasy about requesting home working earlier into her new role, but after settling into the company, she felt the time was right to see if there would be any flexibility in how she works, and so has applied for flexible working to work from home full time. So upon receipt of a flexible working request, Donna's line manager invited her to a flexible working meeting to discuss this in more detail. During the meeting, he asked her to talk him through her request and how she'll manage her day-to-day tasks at home instead of completing them in the office. So Donna explains her role doesn't involve a lot of face-to-face collaboration with a team, except when they have the weekly Friday meeting where they discuss the challenges and successes from the week, planning any upcoming work for the following week, and spend time focusing on any new ideas for continuing to grow the business. So the second half of this Friday meeting is quite relaxed, and the manager provides lunch for the team as a thank you for all the hard work during the week. Donna regularly visits her clients on Friday afternoon after lunch, but feels that this could be carried out virtually. No additional technology is required to facilitate the home working, as Donna works from her laptop and has an existing office where she can work from home. During the discussion, Donna and her manager talk about the importance of maintaining that good relationship with her colleagues, and they agree that the face-to-face interaction does encourage more discussion around growing the business, and there's usually a good collaboration of ideas. Donna notes that she values the time spent with her colleagues during the lunch and feels that it does actually help with maintaining that good relationship that they all have. They also discuss the client meetings and how the long-standing relationships that they have with the clients come from that face-to-face interaction, as it is more personal. Donna's manager asks her how she would feel if she could work from home Monday to Thursday and attend the office in the morning and then do the client visits on a Friday afternoon as she does now. Donna agrees, she's happy with that, and so they both agree that flexible working request on that basis.
Fantastic, brilliant. A question just came through quickly there. I'll just quickly answer it. It's with regards to not being able to see other people's questions. Unless we answer them, you won't be able to see a question pop up there, just in case it's got sensitive information in. But if we can, we'll share it during the Q&A session. Don't you worry. And next, so thank you very much for that, Kelly. Next, Katie, do you want to talk us through the next case study, please?
Yes, thank you. So the second case study is an employee who requested remote working as a reasonable adjustment due to his health condition. So John has been working at home since the pandemic, like quite a lot of people. John's autistic and he's always struggled to attend the office prior to this due to his social anxiety as well as the autism. So his manager has asked him to return to the office and it's been really sensitively trialed several times. But each time John has identified issues, so for example, with the open plan office and the acoustics, which he advises just causes him to struggle to concentrate too much. Now, occupational health agree that John's autism and his increased social anxiety do prevent him from attending. Attempts to push him to return have caused John to raise a grievance if he's forced to, and he'll probably leave or be dismissed for not attending if it comes to it. Now, John has made a flexible working request to vary his contract so that he's a permanent remote worker, and he's cited his disability as a reason for that. So John's performance is good, albeit there are concerns about his attendance levels, his absences. John also refers to his mother being in her late 80s. She's living with him and they support each other as she's physically disabled. Occupational Health have said that if he was permitted to work from home, his absence levels due to his anxiety are likely to reduce. So John's manager is seeking advice. And in that situation, she accepts that whilst it's not ideal, she can manage any underperformance as it arises with John. And as he's able to manage his role remotely, albeit it's not ideal to have him do it that way, she's likely to accept it. The condition is likely to have this impact on John for the foreseeable future, and so she might be best advised to do so. She thinks that some of John's colleagues, though, might feel aggrieved that their applications have been refused, whereas John's has been accepted, and they're just going to have to be advised that they don't have John's condition, and it is what it is.
Absolutely, absolutely. Thank you for that, Katie. That was an interesting one, that one. And who would like to discuss the third one?
Thanks. I'll take this one. This is about somebody returning from maternity leave, one of the instances we talked about. So Claire is one of 3 team leaders looking after a team of 20. Now, prior to going on maternity leave, Claire was awarded and exceeded in 4 out of her 5 last years and even received an award for her outstanding contributions to the business. Now, Claire's manager, Mike, is 3 months into the role and doesn't really know Claire personally. He did inherit a team with significant challenges around productivity and performance that he's got to look after. Now, Claire has applied to work from home for 3 days a week and to also compress her hours so that she has 1 non-working day per week. Now, Mike had a brief call with her to discuss, in which she said that if it can't be agreed, she might unfortunately have to leave, as her and her husband just can't afford childcare for 5 days per week. Mike ended up rejecting the application, and then Jim, head of operations, heard the appeal. Now, Mike had cited a possible reduction in Claire's performance as one of the reasons he rejected her application. Now, on this point, Jim found that Mike was wrong to do that, and his finding that Claire's own performance might be impacted wasn't based on any evidence at all for him to come to that conclusion. Now, as regards the team impact, Jim looked into it. So he noted that Mike hadn't even discussed with Claire how her working at home and working different hours might impact her ability to support the team. As Mike explained, that he didn't see any point discussing it with her because she'd been out of the business. So having discussed it with Claire in that detail, Jim was of the view that whilst the arrangement again might not be ideal, he accepted the application at that stage because Claire was able to show him that nowadays her colleagues tend to hold one-to-ones and coaching sessions mostly online anyway, and there wasn't any shortage of cover from the other team leaders for her non-working day. So they ended up reaching a compromise that if an important meeting fell on her non-working day, Claire would swap that day with notice so that she could attend. Now, Jim's decision at appeal stage protected that business from a potential claim for failure to consider the request properly, for constructive dismissal, and possibly indirect discrimination as well. Plus, the business got to retain an important, high-performing and skilled colleague.
Good on Jim for looking deeper into it in that scenario, I say. Now, great information from you both there, Kelly and Katie. So thank you very much. You've shared a lot of information for us, and also it's going to be reflected upon during the slides as well. Following on from that, though, we have had a few questions. So just before we close off the session, let's tackle a few of those. So the first question that I've noted here is, if we accept one or more requests to reduce hours or change the days an employee works, does that mean that we have to accept everybody's request?
I'll take that one. So no, whilst every flexible working request must be seriously considered, each request must be considered at the time and based on the business feasibility. So let's take an example of where two members of the team previously requested to have Monday as a day off, and that was accepted. If a third employee later requests to also not work Mondays, and this then means that there wouldn't be enough people in work to manage the workload on this day, you can legitimately decline the request for the next employee as long as it's connected to one of the 8 business reasons. So in this example, there potentially would be a negative impact on meeting customer demand. You would, however, need to explain this clearly in the outcome letter.
Spot on. Thanks, Kelly, for that one. And now the next question. If an employee requests flexible working, and this is not reviewed at the end of the trial, but the business can no longer accept the request, can the request still be rejected?
Thanks, I'll jump on that one. This would depend on how long the employee has been allowed to carry on, and with the change after the trial has concluded, how long that was. So there could be a risk that the changes the employee has been working could be considered permanent if there hasn't been a formal review at the end of the trial period, or if there was no agreement to extend that trial. And if there's been an extended period of time since the trial period ended, and the employee is considering this to be a permanent change to their terms and conditions, they could raise an ET claim for failing to follow that statutory process, i.e. to review and then conclude the process within a 2-month period.
Spot on. Superb. We've got time for just one more if that's okay. If an employee has an accepted flexible working request but moves into another role, do they automatically continue with that working pattern in that new role?
I'll answer that one. So in short, no, unless the change of role allows the same terms and conditions. But if that new role requires full-time hours and the job advert clearly stated it is for a full-time role, then the employee is applying for the role based on the terms within that advert. And if successful, then that's what they're agreeing to work. There could, however, be a situation, let's say, where there's 2 successful candidates who are happy to job share. And if so, that might be a solution. Or a manager may decide that the role can be carried out with the successful candidate's current working pattern. So it's not an automatic, it all depends on the sort of needs of the business and the needs of that role.
Spot on, Kelly. Thank you very much. Superb questions came in, and I've noted that there's a lot more questions came in during the Q&A session. Do not worry, we will be in touch with you with answers directly after the session is concluded. Now, it may take some time to answer those, so please allow around about 24 to 48 hours if that's okay. But again, super duper. Thank you very much, Kelly. Thank you very much, Katie, for your input today, and again, your wealth of experience. And don't forget, just a few things before we finish. If you'd like our help with anything that we've covered, please feel free to check out any of the topics covered in the Sage HR Advice portal, or alternatively, if you're a professional or premium customer, please do not hesitate to call this advice line, where one of our consultants will happily provide any guidance on the topics that we've covered today. Now, I'm going to be running a poll shortly just to offer you the chance to hear more about these products. There's no obligation, obviously, but with the ever-changing world, it might be something that you're keen to look at in a wee bit more detail. And just to let you know, alongside Sage Payroll, we offer other people solutions such as Sage HR and HR Advice. Now, Sage HR enables you to automate and simplify your HR tasks, ensuring you manage your employees fairly and consistently, supporting productivity, well-being, and job satisfaction within your workforce. You can also trust that with Sage HR Advice, you'll remain up to date with the latest employment law, HR, and health and safety legislation supporting your business work within legal frameworks, reducing the risk of tribunals and penalties. So I'm going to run the poll now. And if you'd like to hear more, just select one of the buttons and we'll be in contact. After this has been on your screen for a minute, I'm going to go through what's up and coming with our webinars as we head into February. So this will be on there for just a moment. And make a selection. I'm going to put myself on mute just while I prepare the next slide for you. I'll be back in a minute. Superb. I'll give it just now 30 seconds there. And as I say, we're already collecting these questions so we can get in touch with you afterwards. So again, if you still do have questions or feedback forms after this session is concluded, you can always ask a question as well as providing feedback on the session today. We read absolutely every single comment. So I'm going to thank you in advance for completing that. It'll only take 2 minutes. It'll be wonderful. Brilliant. Okay, I'm going to end the poll there now. And what I'm going to do, share with you our calendar. Here it is. So this is our end of January up to February calendar. Our next webinar in partnership with Advisor Plus is going to be on the 29th of January at 11 a.m. And that is HR Advice Uncovered, how to access instant expert HR guidance. That's going to be a very good one. It's a bit ad hoc, but it's going to give you a whistle-stop tour, everything that you need to know about HR advice guidance. So get registered for that one at sage.co.uk/webinars. Superb. Now, all that's left for me to do is thank you for your ears and attendance today. It's been wonderful speaking to you all. Again, a massive thank you to Katie and Kelly. We hope you enjoyed this session. Let us know in that satisfaction survey afterwards as well, what you liked, what you didn't like, what we could improve on, or what you'd like us to keep. And also if you've got any questions for us. But with that, with it now being 11:47, we ran over slightly by 2 minutes. I'm going to leave you all to your busy days. Again, thank you very much, and hopefully we'll see you all soon. Bye for now.
Bye-bye.
Thank you. Bye.